Good morning, leadership. Just testing if we are audible on our side. Thank you.
Good morning. We can hear you.
You don't know.
Recording in progress. Recording stopped.
Good morning, members. Good morning to the Minister and the Deputy Minister. Good morning to
Morning, Chair.
the Acting Secretary General and the team from the OCJ. Members, today we are
Recording in progress.
attending to the annual report of the Office of the Chief Justice. So, Committee Secretary, do we have apologies?
Good morning, Chair. We have apologies from Ms. Dana and Mr. Glober.
Okay, so we've got two.
I'm not so sure if Mr. Tsotit is going to join us today, but yeah, he tendered an apology for yesterday's meeting, but I don't know if it also covers today. I'll have to find out from him.
Okay, that's fine then. Minister, should we give you now so that you also tackle the issues that were raised yesterday, or we give you after them?
No, let me start, Chair. Thank
Okay.
you very much. Good morning to you, Chair. Good morning to members. I do think that I should start. I'll deal overview because members wanted to know from yesterday, and I think I should be able to give that highlight of how far are we with the process of single and independent judiciary-led administration. I didn't greet everybody. My apologies, DM and team from OCJ, led by the ASG. I need to update Parliament on the following in this regard. We started the process as we reported and put together two task teams to work between the judiciary, the OCJ and the DOJ. And out of those, the work streams were developed in terms of working in the areas. The first one, Chair, was to transfer shared services with effect of the 1st of April 2026. The second phase will be in terms of legislative amendments and also transfer of lower courts into to join superior courts. I was warned by magistrate that I must not use this word as lower courts because it seems like it's undermining them. But I know it's commonly used by all of us. So magistrate courts so that they are transferred to the judiciary. So in that, then we held a meeting with the magistrates, regional presidents, also the chief magistrate forum jointly with the DM, to take them through what is envisaged. We were joined by the chairperson of the commission, including the secretariat, magistrate commission, to take them through in terms of the process, what is expected and the phases, but also to bring them on board in terms of their role, and so that they also participate and make inputs. Out of that meeting, we agreed that they will give us a team that will be consulted with throughout the process. So they've agreed on 5 regional presidents and also 5 chief magistrates, which is a team of 10 people. And those will be a tripartite alliance of some sort between themselves, and the OCJ and the DOJ, so that judiciary, so that there is consultation consistently throughout. That's the first thing. But in that meeting, it was highlighted that they had not seen the WEPE report, which is the basis that we are utilizing to establish policy of this process, and we agreed that they will take this document, go through it, and make their inputs by January 2026, so that the policy process can start. We are not able to start having a draft bill without having policy positions. And also we held a meeting on the 13th of November with the judiciary just to give them an update, or all of us to look at the progress for the teams to report. It was clear in the meeting that the judiciary is not comfortable as yet. They gave us conditional approval, subject to certain things that needed to be done. And we've requested that if they can give us that feedback before end of November or latest first week of December, for the transfer of shared services from the 1st of April 2026. The reason being, Chair, is that they felt that there's a lot of gaps in terms of funding, which is true. Because we are not fully funded. There are areas where we would have requested particular funding and it would not been given. So that money would not be existing with DOJ. What I encouraged was that can we look at what is currently available and transfer, and then the judiciary engage with finance on the gaps. But there was still not comfort with that. And therefore they wanted to do some level of assessment. And we've agreed out of that process that they will appoint a project manager to lead this process from their side, who's an expertise, can look at the risks, because they were worried about the risk. One of them is around what are the contingent liabilities for them as they take the responsibilities. So it's still a long way for us on this in this regard, Chair. And we'll continue to work in that form. I thought it's important to give this update. It's work that we are doing. I can't confirm now if the 1st of April would mean transfer of those responsibilities to OCJ. We believe we should do it. The judiciary is not comfortable, and we felt that, okay, let's allow them to look at their areas of concern so that we can deal with that. So we'll keep the portfolio committee updated and Parliament updated in this regard, especially as we look towards concluding the issues around the policy. The major contestation as well in the policy is accountability mechanisms. We do feel that the judiciary will have to account to Parliament for particularly administration and financial responsibilities in terms of identifying the executive authority. So the model that is proposed in the Ngwepe report is different. It's a committee. We do feel that it might be a bit of a challenge. So we're still looking at that. They've asked us to say, okay, let's look at the model. Cabinet said they do flag this, but also ask us to look at what are the options and what are the global other parliaments or other countries are doing, how do they account, so that we can close that gap. So we'll come to Parliament for that as well in terms of the work. Chair, we have not concluded the appointment of the acting of the Secretary General. With my arrival, the post was advertised, and then the judiciary as well, with this conversation of judiciary-led administration, has been a to and fro at some point in terms of who should lead in the appointment. The current legislation does lead, say that it should be the minister. We're currently finding a hybrid model in understanding that the intention is to transfer this responsibility to the judiciary, and therefore it would be unfair for the minister and other ministers or cabinet to appoint a secretary general for the judiciary, while we are saying that we're transferring this responsibility. So we've had the meeting of shortlisting jointly with the judiciary, almost like contributing technically, because the current law doesn't allow them to be full members. So we had full component of the membership in terms of the panel as required by the law, and also we allow them in because the law does allow for technical participation. So we've done that. We've done the shortlisting. We're looking at the dates which is suitable for interviews. We'll look into that so that we can be able to interview in regards to the Secretary General of the OCJ. What delayed was this mechanism of how can we do it, and so that it's not seen as the executive imposing a person while we are saying that we're handing over the process. So that's the reason why the appointment has not been made. Chair, noting that there's been pressures as well, I do understand even today. I'm going to ask the Secretary General to make the presentation. In the presentation, some of the issues in terms of the court online process will be answered, and the audits around that. I think that was the issue that was pending. And then in terms of infrastructure that, and also it will be responded to. But what we have done as well, in part of these meetings that we have, the heads of courts, where we've brought even other ministers, including Minister of Public Works and Infrastructure, we've identified that current budget will not allow us to respond to the entirety of the infrastructure, as TT would have said yesterday. And one of the models being used now is to look at public-private participation. You'd have seen the launch of a partnership for the upgrading of the Johannesburg precinct. So we're looking also with the infrastructure fund to look at new buildings that can be put into the infrastructure fund for them to lead in terms of that. So there are mechanisms that are being looked at in terms of infrastructure for the superior courts as well. And upgrading. Also, the other issue I need to report to members is that you'd remember Minister Lamula had appointed the former Deputy Chief Justice Musaneke to lead in terms of the rationalization of the courts, both in terms of capacity, the areas we needed to improve, the infrastructure. That report has been presented to me. We'll be taking it to Cabinet. We've consulted with the judiciary in the meeting of the 13th. They've requested more because they're saying that there are areas that are not comfortable. We've proposed that areas of contestation, we put them, but implement the report in phased-in approach, because there are areas where there is no disagreements, and we don't believe that there should be delays in implementing parts of the report because there's one area that is a delay, is a contestation. So we've agreed that we'll take this report to Cabinet and we'll bring it to Parliament as part of our work to implement that, and it will respond to the challenges in terms of human capital, capacity around the judiciary. It proposes in terms of number of judges that must be increased. 2, it proposes the format of the judiciary in terms of one of the proposals with the judiciary highlighted to me that it is the purview of the Chief Justice, but the report also proposes the doing away of recess, but having judges as well taking leave. We'll table it formally, Chair, to commit to Parliament so that as well Parliament can interrogate it, because this is the work that we do believe that response to restructuring of the judiciary, doing away with the apartheid infrastructure or even alignment, because we still continue with alignment of infrastructure. And if there's anything about transformation of the judiciary as well, part of it is what this report actually proposes, and would want to see it being implemented because it will respond to what has been raised previously. With that, Chair, thank you very much. I'll hand over to the acting SG to be able to do the presentation together with the team, and then we'll come in. DM will lead afterwards in terms of first closing and then taking the responses first as well. Thank you very much. Over to you, ASG. The documents were shared with members, so we are going to request that we don't go line by line. We speak to the presentation and highlight. So the missions and missions are known, visions and missions are known. Let's get to the point so that we are able to allow for extensive discussions with the committee. Thank you very much. Over to you, Acting SG.
Good morning and thank you, Minister. Good morning, Minister, the Honourable Chair and members. I am Marilise Potgieter, Acting Secretary General of the Office of the Chief Justice. With me, I should note, is the EXCO members, and they are also ready to take questions from the members. Without further ado, members, just some introductory remarks before I'll hand over Chairperson with your permission to Mr. Masilu, who will take us through our achievements during this reporting period. And finally, the CFO will highlight our achievements and financial management figures. Chairperson and members, the OCJ continued to execute its constitutional mandate in supporting the judiciary. During the reporting period, we've achieved 83% of our targets compared to the 86% of the previous year. And although the detail will be indicated later, The targets that we failed to achieve related to the vacant funds, funded posts, staff comprising of youth, and the percentage of women in SMS positions, and the percentage of procurement of goods and services above 500,000 awarded to suppliers who meet specific goals. Now, chairperson and members, 3 of those targets relate directly to the Circular 49 of 2023, the austerity measures that were implemented, cost containment, and that has hampered mostly the capacitation of the OCJ and achievements of those 3 targets. However, the OCJ team has excelled by again achieving a clean outcome, audit outcome for 23-24 financial year, and we've also been informed of the 24-25 clean audit outcome. As part of our ongoing promotion of access to courts, the rollout of Court Online system was also a significant achievement by the OCJ. During the reporting period, another 6 were rolled out. During the compilation of this presentation, I've mentioned the 15 service centres. However, it's my pleasure to indicate to the members that we currently on 21 as of date, 21 service centres with only our Apex Court and SCA to pronounce a go-live date. As asked yesterday during the presentation, which the Minister has also alluded to, I may inform the committee that on 27 May 2025 this year, the High Court of South Africa, Gauteng Division in Pretoria, granted an order in favour of the OCJ in which it seeks to self-review its procurement of case lines from Thomson Reuters, known to be the TR matter. So, members, just to add, the civil matter has therefore been concluded. The court pronounced that the interim contract is valid until the fresh procurement process has been concluded. Confirmation was received from SITA that the procurement is ongoing, and will keep the committee informed. With regards to the criminal matter, it's best suited to inquire from the law enforcement agencies who are directly tasked with that matter. I may inform the committee that the criminal matter was postponed on the information that I've received to February 2026 for a ruling or judgment on a special plea. If I may proceed then, our pursuit in installation of backup generators and water tanks are mostly ongoing, depending on availability of funding. Chairperson and members, the OCJ was allocated during this reporting period of a budget of 2.6 billion. 1.2 was allocated to the vote and 1.3 billion to the direct charge for judges' remuneration and benefits. As was previously mentioned to the committee, the OCJ has struggled to stay within that reduced budget, and unfortunate overspending of 108% was then recorded at the end of the financial year. The CFO will go into detail on that overspending. The National Treasury has allocated additional budget over the next MTF to the OCJ, and that will ensure that the OCJ is adequately capacitated to enhance the support to the judiciary. Now, I must mention that we We were able to get this additional budget with the assistance of our executive authority, the minister, in conjunction with the portfolio committee, who has noted the struggles of the OCJ to support the judiciary in this regard, and for that, we are really grateful. So the OCJ has been, in the current financial year, embarked on a recruitment drive to capacitate the institution. In this sense, I may mention that for the first time, we were able to capacitate the private office of the Chief Justice. We've also managed to capacitate the private office of the Deputy Chief Justice. All heads of court were capacitated with office managers. We are also in the process of appointing handymen to save costs on service providers just for the replacement and repairs of infrastructure. We have started to increase the research capacity by looking at our APEX score and our SCA, and we will proceed on that trend in the next financial year. So to that end, committee and chairperson, we have managed to support the judiciary by enhancing the capacitation. And it's also very important to note that we were crippled, the OCJ National Office, as we couldn't appoint SMS members. That has changed, and as the Minister has indicated, the SG post is still vacant, but we managed to fill our SMS positions and to strengthen our management in that regard. Thank you, committee. I'm going to hand over, with your permission, Chair, to Mr. Masilu, who will present high-level achievements of our 24-25. Thank you, Chair.
Thank you, Acting SG.
No, thank you very much, ASP, and thank you very much, Chairperson. Good morning to you and to portfolio committee members, and good morning to you, the Minister and the Deputy Minister. Chairperson, the purpose of my presentation is to highlight both the financial and non-financial performance of the department.
Yeah, but where are you?
Slide number 6.
Know yourself, where are you?
Chair, you are not muted.
Yeah, I'm asking the presenter, where is he? We can't see him.
Okay.
We're just making changes in seating arrangements, Chair, with respect to show that Mr.
Yeah, if you are in the same boardroom, Acting SG, you can give him the chair.
Absolutely. Thank you, Chair.
Yeah, you can proceed now.
Oh, good morning, Honorable Chair. Yeah, I'm here.
Not there.
Yeah, we can see that you are here now.
Oh, okay, no, so thank you very much. Okay. The purpose of my presentation is to provide an overview on the financial and non-financial information of the department during the 2024-25 financial year, and also to highlight some of the achievements as well as the challenges that we encountered during the year in question. Next slide. Then in terms of slide number 6, it deals with the proclamation and the establishment of the Office of the Chief Justice, and it also outlines who is responsible for accounting on behalf of the department. and who's the executive authority of the department. Then moving along to slide number 8, it outlines the legislations as well as the prescripts that we considered while we were developing the annual report of the OCJ during the 2024-25 financial year. And amongst others, we considered the National Treasury Guide for National and Provincial Department, which was issued in March 2025. And we also considered the Constitution Public Finance Management Act. Then we also considered the Department of Performance Monitoring and Evaluation Revised Framework for Strategic Plans and Annual Performance Plans. Then moving to slide number 9, we have highlighted various stakeholders that were consulted while we were compiling the annual reports. We consulted the ministry, we consulted the DPLE, National Treasury, as well as the AGSA. Then internally, Chairperson, we consulted the OCJ Audit and Risk Committee. We also consulted the OCJ Executive Committee as well as the OCJ Operational Committee. Then in terms of Part A, which is on slide number 11, it highlights the vision, mission, and values of our department, which remain the same and they are not changed. And I'm not going to go through them through your permission check. Then in terms of slide number 7, it outlines the mandate and functions of the OCJ. They also remain the same and they are not changed. And I'm not going to speak to them as they are outlined in the slide. Then slide 13 to 16, check. They outline the legislative and policy mandates guiding the work of the Office of the Chief Justice. And through your permission, allow me not to go through all these pieces of legislation as well as the policy mandates guiding us. Then I'll quickly zoom into slide number 17. Here we are reflecting the impact statement of the OCJ and how our 3 outcomes are linked to both the MTSF priorities as well as the national development priorities. The reason we are highlighting the MTSF is that during 2024-25, the MTDP was not yet introduced. So we are still teasing out how we link ourselves to the government priorities. Then moving along to slide number 19, we are highlighting our performance during the 2024-25 financial year, where we had 24 planned targets of annual targets, of which 20 targets translating to 83% were achieved. Then 4 targets translating to 17% were not achieved. And safe to say that the targets that were not achieved are mainly from Program 1, which is a administration program, but then we'll speak to that as we move along through the presentation. Slide number 20 highlights performance of the OCJ per program. As we know that the OCJ carries out its mandate through 3 programs, which are administration, superior court services, as well as judicial education and support, with the Program 1 having 13 annual targets, and 9 targets translating to 69% were achieved. Then 4 targets translating to 31% were not achieved. Then both Program 2 and Program 3 achieved all their annual performance targets. Slide 21 reflects our performance trend from 2019 to 2024-25. Let me take it from 2020-21 to 2024-25, just to align myself with the 5-year term. For the 4 years of 2020-21 to 2024-25 5-year term, the OCJ achieved more than 80% of their annual targets, with the exception of 2022-23 financial year. And the reasons thereof have been presented to the portfolio committee previously. Then in terms of slide number 22, it reflects our achievements during the year in question, and amongst others, it's with regard to the achievement of 2% representation of people with disabilities by the end of the year under review, Secondly, the court online was rolled out to 6 service centers, but then as at the end of the term, we rolled out court online system to 8 service centers. The third one is with regard to the training of staff on workplace skills plan, whereby 1,128 of staff were trained in line with the WSP. In terms of other achievements, the department managed to investigate 33 of 35 reported fraud cases within 60 working days. Subsequent to that, the department finalized 95% of default judgment by registrars within 14 days from date of receipt of application. Then we managed to finalize 99% of taxations of legal bills of cost within 60 days from date of set down. And through SAJAI, we conducted 141 judicial education courses, which were attended by 3,745 delegates. Then the next slide, Chair, we are highlighting some of the challenges that we encountered during the year under review. And among others, it was with regard to the implementation of the PSA Circular 49 of 2023, where some of the funded vacant positions were not filled. The second one is with regard to the national budget cuts, which was implemented during the 2024-25 financial year. However, the Circular 49 has now been discontinued, and the department is in the process and implementing the filling of vacant positions. In terms of slide 24, I'm highlighting the budget program structure of the department, whereby we carry our mandate through 3 crossroads. Then I'm going to zoom into performance of Program 1. As we all know, that Program 1 carries its mandate through 5 sub-programs. There's the management sub-program, corporate services, internal audit sub-program, financial administration, as well as office accommodation. Then in terms of performance per sub-program of Program 1, management sub-program did not have annual targets during the year in question. Then corporate services had 8 annual targets, of which 5 targets were achieved and 3 were not achieved. Internal audit had 3 planned annual targets and were all achieved, with financial administration having 2 planned annual targets, of which 1 target was achieved and the other one was not achieved. And office accommodation sub-program did not have any annual targets. Then on performance against set targets in the APP, the first output indicator that was not achieved is on the percentage of vacant posts on funded establishment. We had an annual target of 10% or lower. Then the actual output was 12.34%. Then there was a variance that we have outlined, which is 2.34%. We have provided the reasons, amongst others, is the implementation of the BPSA Circular 49 of 2023. That one of the cost containment and the budget constraint. Then we have also highlighted the corrective measures, and we are committing ourselves that with the discontinuation of this Circular 49, we are committing ourselves as a department that all vacant positions will be filled. The second output indicator, which was not achieved, is on percentage of staff in the department comprising of youth. We had an annual target of 30% with an actual achievement of 26.4%. Therefore, it implies that the variance is 3.6%, and we have highlighted the reason for deviation with the DPSA Circular 49 also featuring on this output indicator. Then the other one is with regard to resignation of officials who fell under the category of the youth, and others overcoming their youthfulness category. Then in terms of our commitment in ensuring that we've got youth representation in our department, we are committing ourselves that the OCJ will continue to ensure that future vacant and approved posts are structured to attract and appoint youth. And also we will explore employment initiative provided by the government, like your presidential programs. Moving along to slide number 28, the output indicator on percentage of women representation in senior management. We had an annual target of 50% with an actual output of 47.05% and the variance of 2.95%. Then the implementation of Circular 49 also is featured on the reason for deviation, then which prevented us to fill in position when officials left the department. And safe to say that we had some women and SMS members who left the department during the question. And as the department, we are committing ourselves that going forward, we'll prioritize the appointment of women in SMS position. And the other output is on percentage of people with disabilities representation in the department, and I can safely say that we are doing very well on that one. We had an annual target of 2%, and we had an actual output of 2% with no variance. The same applies with number of employee health and wellness programs implemented within the OCJ. We had an annual target of 16 with an actual output of 60, and therefore there was no variance. Again, one other output indicators and targets that were achieved is on percentage of staff trained in line with the workplace skills plan. We had an annual target of 80% with an actual output of 91%. In this regard, there was an overachievement of 11%. And the reason for overachievement, Honorable Chair, is due to a concerted effort of implementing training for civil services sites that encourage the release and increased attendance of pledged training by officials. Then on the number of service centers with court online system rolled out, this has been the priority of both the executive authority as well as the judicial chair. We had an annual target of 2 and an actual output of 6, which simply means that there was an overachievement of 4. And the reason for overachievement was that as the department, we committed ourselves to fast track the implementation of the court online system. In addition to that, there was a high demand for rolling out the project at service centers to improve service delivery. Then on the ICT disaster recovery strategy being implemented, we had an annual target of maintaining ICT disaster recovery sites. Then this annual target was achieved. There was no variance in this regard. Then in terms of the audit outcome for the OCJ as an output indicator, we had an annual target of a clean audit outcome for 2023-24 financial year. And I can safely say that, Honorable Chair, it was achieved and there was no variance. On percentage of procurement of goods and services, about 500,000 awarded to suppliers who meet service goals, specific goals. We had an annual target of 80% with an actual output of 71%, which translates to the variance of 9%. The non-achievement of this output indicator and target, Honorable Chair, was due to that as the department, we awarded, there were 7 awards, and 5 met the specific goals, and the other 2 did not meet the specific goals. However, they were the highest scoring bidders for the project. But then as the department, we can explain it further. Then as the department, we are committing ourselves that in ensuring 80% procurement of goods and services above 500,000, being awarded to suppliers who meet the specific goals. The department will deploy a goods sourcing strategy for procurement of items outside RT and CETA. On percentage of designated employees, Honorable Chair, mainly on SMS members and other categories to submit financial disclosures within time frame, we had an annual target of 100% and it was achieved. And this is the target that we have been achieving over the years. It's about the issue of compliance. On percentage of reported fraud cases investigated, we had an annual target of 75% and an actual output of 94%. This signifies an overachievement of 19%. And the reasons for overachievement is due to the enhanced internal processes, including streamlined case tracing, prioritization of cases with readily available information for prompt investigation, and regular performance monitoring contributed to sustained motivation and adherence to investigation timelines. The last indicator under Program 1, Chair, is with regard to the number of fraud prevention and anti-corruption awareness sessions being conducted. We had an annual target of 28 and an actual output of 31. This means that we had an overachievement of 3. And the reason for overachievement was due to a new DPSA directive and remunerative work outside the department, which necessitated our awareness sessions before its implementation. And furthermore, to ensure all staff were accommodated, the department proactively had both physical and virtual awareness sessions, building upon the initial planned physical sessions. So, Honorable Chairperson, this is the performance of the OCJ on Program 1. I'll quickly zoom into performance of the department, mainly on Program 2, which is the Superior Court Services. And is the core business of the department. As the department, Program 1 had 6 planned annual targets, and I can safely say that all the annual targets were achieved. And this is the program that has been audited by the Auditor General of South Africa, and there were no material findings that were identified by the AGSA on performance information under this program. Then moving to performance against the set targets in the annual performance plan. On percentage of default judgments finalized by registrars within 14 days from date of receipt of applications, we had an annual target of 90% with an actual output of 95%. This signifies an overachievement of 5%. In this regard, the reasons for achievement is due to improved training and monitoring measures implemented to sustain achievement of targets. On percentage of taxation of legal bill of cost finalized within 60 days from date of set down, we had an annual target of 90% with an actual output of 99%, signifying the overachievement of 9%. And the overachievement was due to improved training and monitoring measures implemented to sustain achievement of targets. The third output indicator is on percentage of warrant of release delivered within 1 day of release issued. We targeted 100% during the year in question, and it was indeed achieved. On the fourth output indicator is on the number of monitoring reports on law reporting projects produced. We committed to produce 4 of them. And yes, the 4 reports on law reporting projects were produced. The fifth one is on the number of judicial case flow management performance reports produced. We had an annual target of 4 with an actual output of 4. This simply means that there were no barriers in this regard. And the last output indicator under Program 2 is with regard to the number of reports on enhancement of court order integrity produced. With an annual target of 4 and the actual output of 4. There is no variance to this. Honorable Chair, this marks the end of my presentation on performance of Superior Court Services. Then I'll zoom into Program 3, which is Judicial Education and Support Program. Program 3, which is Judicial Education and Support, carries out its mandate through 3 sub-programs. The first one is the South African Judicial Education as a sub-program. The second one is the Judicial Policy Research and Support sub-program, and the last one is the Judicial Service Commission. Then in terms of performance, the sub-program SAJ had 2 planned annual targets, and all the 2 planned annual targets were achieved. Then with Judicial Policy Research and Support, we had 2 annual targets, and they were all achieved, translating to 100%. And lastly, for Judicial Services Commission, we had 1 annual target and it was achieved. Chairperson, the next slide depicts those output indicators and targets. The first one under SAJ, number of judicial education courses conducted. We had an annual target of 120 with the actual output of 141. This means that we had an overachievement of 21, which means that additional 21 judicial education courses were conducted. And the reason for additional 21 judicial educational courses being conducted was mainly due to for new district managers who were appointed in August 2024. So as such, we had to also conduct and comply with such a act. The second output indicator is on number of research monographs on judicial education produced. We were targeting 2, and I can safely say that 2 of them were produced with no variance. The third one is on the number of monitoring reports on management of litigation produced. We targeted 5, and the actual output was 5. The next output indicator is on number of reports on status of disclosures for judges' registrable interest produced. Our annual target was 2, and our actual output is 2, which simply means that there is no variance on this output indicator. And the last output indicator under Program 3 is on the number of reports on judicial appointments and judicial complaints produced. We had a target of 3 with an actual output of 3. This simply means that there was no variance in this regard. Chair, thank you very much. This marks the end of my presentation on performance of the OCJ against the output indicators and targets outlined in the APP. I'll quickly zoom into Part C, which I'll tease out our AGSA audit outcomes. Slide 43, it depicts performance or the audit outcome of the OCJ from 2017-18 to 2024-25 financial year. And the focus areas were outlined in this audit coverage include the annual financial statements, the annual performance reports, the compliance with legislators, and overall the audit opinion. With your permission, Chair, let me speak to the financial years from 2022 to 23 to 2024-25. And I can safely say that in terms of the annual financial statement, annual performance reports, as well as compliance with legislation from 2022-23 to 2024-25, meaning for 3 successive years, there were no material mistake statements that were identified on those 3 focus areas. It has been assured. Chair, moving to slide 44. It's a replica of what I've presented in the previous slides, and if you look into the audit outcomes for the past 8 years, the OCJ has been obtaining a clean audit for 6 years. Yeah. And in terms of the reasons for us maintaining a clean audit has been outlined. It's due to the quality review processes that the department has implemented and maintained. And we are committing ourselves as the department that even in 2025-26, going forward, we will maintain the standard. Thank you very much, Chair. And on the next slide, Chair, it outlines the AJSA focus area and audit outcome for the 2024-25 financial year. And through your permission, Chair, allow me not to speak to that. I've already outlined the focus areas as well as the audit opinion or audit outcome from 2022-23 to 2024-25. And I can safely say that on the annual financial statement, performance information, as well as compliance with legislation during the year in question, there were no material misstatements, no material findings on the usefulness and reliability of the audited reported performance information, and no non-compliance material findings were identified. Hence, the clean audit opinion from the HSA. Then my last presentation will be the overall audit outcome, which is also the repeat on this one. When we look at the colors on financial statement, annual performance report, as well as compliance with legislation, the OCJ from 2022-23 to 2024-25, we have been clean. There has been no material findings. Chair, on that note, I would like to take this opportunity to affording me the opportunity to present the non-financial information of the OCJ to yourself, as well as to honorable members of the portfolio committee. I thank you, Chair. With regard to financial information, the CFO will speak to that.
Thank you.
Morning, Chair. Morning, Minister, the DM, and honorable members. I'm going to present.
Where are you, CFO?
My camera is on, Chair. Can you see me?
No, we can't. We see the acting SG. We see the boardroom on the other side.
Thank you, Chair. Yeah, I think you can.
Yes, we can see you now.
Yeah, thank you, Chair. Yes, I'll be taking the members and honorable members through the financial performance. The first slide on the financial performance, Chair, is just the breakdown of our budget, just to indicate that most of our budget, out of the 2.8 billion that we have, 75% is for compensation of employees, of which voted funds is 923 million to 9, and the direct charge is 1.2. And then when we go to goods and services, we then had 453. We spent, these are the expenditure that we had, not exactly the budget. This is what we then spent during the financial year 24-25. We spent 453 under goods and services, transfer subsidies 103, which includes voted and direct charge. Direct charges for the gratuities of the judges, and the purchase of capital assets 130, which includes the judges' vehicles. And the total of our percentage for operational, as even previously we've been indicating that it's almost 24% of 23 for the overall budget for the operation. When we go to the next slide, Chair, is it now gives us the picture of the budget and the expenditure that we had. On the 23-24, our budget was 2.578, and we spent 2.558. And then when we go to 2024-25, we then had a budget of 2.6, but we spent 2.8. We then result as an overspending of 229,445. When we go to program 1, the budget was 260, and we spent 319, which then we had an overspending of 59. 59 million. And then when we go to Superior Courts, 963, we spent 1.1125, which we had an overspend of 161. Judicial education support, where we also is included with JSC, we had a budget of 49,168, we spent 66 million, we then overspent to 17 million. The overall budget for voted was 1.273, and then actual spending was 1.1512,580. We overspent with 238 million. Direct charge, we had an underspending of 9.3. The reason for direct charge also is because of the issue of we didn't pay as we had projected on the issues of the gratuities. And then we then have, as a result, an overspending of 229,445 compared to the previous financial year, where we then spent within our budget. So in the next slide, Chair, is the overspending as per economic classification, where we then indicate that under compensation of employees, we underspent with 3 million, of which our budget was 2,146. Then we spent 2,149, we underspent with 3,816. During the 24-25, National Treasury, through the engagement with them, then they gave us 50 million. That 50 million was just for the adjustments of salaries. Hence, the underspending under COE was lower. And then on goods and services, we overspent with 157. The budget was 295. We spent 453 million, and then we had 157. Transfer subsidies, which includes the judges' gratuities, we had 108. We spent 103, then we underspent with 5.6 million. Assets for the judges' vehicles, you can even see, Chair, in the previous financial year, the budget was 89 on the purchase of capital assets, but in the 24-25, we had 56. So the anticipation for overspending was already identified. Then we overspent with 73. And then also, Chair, maybe on the issue of goods and services, if I go back, you can see last financial year, 23-24, we spent 374, but the budget for 24-25 was 295. Already, even on that one, we did anticipate overspending. On the next slide, Chair, is the reasons for the overspending budget due to budget cuts. It then resulted in shortfall for critical items like network bandwidth for control line system, Microsoft licenses, where we procured, when we pay for this Microsoft, the rand-dollar exchange rate, it was higher, and then the budget for that we budgeted for it, then it exceeded what we projected. And then the other issue on the issues of overspending on program one also, it includes invoices. We didn't include it there, Chair. Just the invoices. When we closed the year 23-24, we had the accrual invoices to the total of 70 million. So across all programs, we had the 70 million then affected the budget, or especially on goods and services and purchase of capital assets. So one of the reasons was also for overspending to pay for invoices which were accrued from 23-24. On transfer subsidies is because of the higher than anticipated leave gratuities for officials who resigned and passed away, which on this one is one of those things that you can't anticipate that how many people will resign. And then on the issue of program 2, also the compensation, it was shortfall, additional funds allocated during the budget adjustments, which were intended to cover the salary adjustments. Goods and services also to shortfalls, including to fleet services, operating lease for judges' vehicles. Additional pressure was experienced in travel and subsistence costs, car rentals for acting judges, permanent judges also. Transfer subsidies the same with leave gratuity for officials who resigned. Purchase of capital assets is due to budget cuts, which resulted in shortfall for funding of judges' vehicles relating to finance lease and also operating, yes, on the finance lease. And then the next slide on program 3, Goods and services also is due to budget cuts and then shortfalls within the judicial education training, as well as the sittings on the Judicial Service Commission. On the SAJE, Judicial Education and Training, the other challenge that we also discussed with National Treasury, during the 24-25 chair, I can't remember, there was 200 and something magistrates that were appointed, and then OCJ only had 7 million to use to fund the training. So you can see those are the challenges that we had, that we won't even know the number of magistrates that are appointed, and then you find that the budget is not sufficient to cover the training, because we even had to go to DOJ to request some of the funding to assist the SAJE to train some of the magistrates. On the issue of underspending under judges' salaries, it's because of lower than anticipated payment of gratuities. I'll give an example, Chair, maybe just to add also on the issue of overspending. Under only SAJE, the one that is responsible for training of judges, the budget was 13,654, and then expenditure at the end was 17,776. Only goods and services, the budget was 2.3, and then the expenditure was 7 million. JSC's budget, it was 11 million, but the expenditure was 16 million. So at the end of the day, Chair, we were going to overspend on all these issues. But as SG has then indicated, through the engagement with the executive authority, the chairperson, the portfolio committee, engagement with portfolio committee, because if Chair will remember, last financial year from first quarter, second quarter, we presented the expenditure for first quarter and second quarter, which we were presenting that there's a possibility that we'll overspend. We engaged National Treasury the first month of April last financial year to indicate to them that we'll overspend. We even had an engagement with the Minister of Finance also through the Minister of DOJ, our minister. So those are the things we did, Chair, to notify National Treasury that through the budget cuts we're going to overspend. But we just want to appreciate, to say, through the engagement of the minister, the portfolio committee, during the financial year of 2025, we've received additional budget of 880. And I know during the audit, they indicated that OCJ cannot afford to overspend again in this financial year. And we've put measures in place that will ensure that we won't overspend again. Thank you so much. I think that's the end of my presentation.
Thank you very much, CFO. DM.
Chairperson and Minister and honourable members, officials of the departments of Justice and Constitutional Development and of the Office of the Chief Justice, very, very good morning to all. Mine are just two very brief comments that flow from the Minister's opening remarks. The first is that the movement towards a judiciary-led court administration model and a single judiciary, I think, are, without running the risk of exaggeration, I think are probably two of the most epoch-making projects that the Department of Justice and Constitutional Development has embarked upon since the advent of democracy in 1994. It really is a major, major step forward to dealing with the outstanding mandate contained in our Constitution that the Minister of Justice and Constitutional Development should, after the passage or the adoption of the Constitution and in consultation with the Judicial Service Commission, come up with a model for the judiciary that's appropriate to a constitutional democracy and the provisions of the Constitution. I think that, as the Minister has correctly pointed out, I think that the two issues that are occupying the minds of both the department and the judiciary, and I think in the near future will occupy also the attention of the portfolio committee and indeed our whole society, is how does one structure the imperative of everyone in our society being accountable, and especially being accountable for the use of public resources on the one hand, and secondly, the issue of being accountable for performance. And I think those two issues are going to require our collective input and wisdom as we go forward with that very exciting project. I think just to emphasize the matter addressed by the minister is that we view the process of moving towards the judiciary-led court administration model as being inextricably linked to the movement towards a single judiciary, because it would, in our view, be very, very problematic that we move to strengthen the independence, the institutional independence of the judiciary on a partial basis, when it should be all-inclusive for the judiciary as a whole. And the minister has alluded to the engagement that we have had recently with the Chief Magistrates Forum, the Regional Court Presidents Forum, and the chairperson of the Magistrates Commission in terms of bringing on board the regional and the district court judiciary. Chairperson, the second point that I want, and related point that I want to make, and that wasn't touched upon, and understandably, but it is, I just want to flag the issue so that the portfolio committee, I think, can also start exercising its mind on it. The reality is that at present, the human and the financial resources devoted to court administration make up a substantial part of the budget and the staff complement of the Department of Justice and Constitutional Development. With the transferring of those functions to the judiciary, of course, the question then arises as to the role and the mandate of a Department of Justice and Constitutional Development in a constitutional democracy. And I think those are issues which the minister and I have started raising with the department to say we need to reconceptualize what role a Department of Justice will play in the future when it is no longer responsible or directly responsible, rather, for matters of court administration. Some would take a narrow view and regard it as a threat, to see it as a diminution of the role of the Department of Justice and Constitutional Development. But I think others would see it as an opportunity, and a very exciting opportunity, for the department to become more focused on matters of policy, on providing quality state legal services in the form of advisory services, litigation services, and improving the quality of the many other non-court related services, such as the Master's Office, and playing a more important role in the overall coordination of matters pertaining to the legal system and the Constitution. So, Chairperson, I think those were really just the two remarks that I wanted to add, and obviously being ready to assist in answering any questions that might arise. Thank you.
Thank you very much, DM. Thank you very much to the team. Members, can we now interact with the report? Honorable Mshala, Honorable Matafa, Honorable Swart, Honorable Breitenbach, Dr. Dr. Litchfield Shabalala, Honorable Mutaung. In that order, members, Honorable Mhlala.
No, thanks so much, Chairperson. Let me take an opportunity and greet the Minister and Department, members of the Portfolio Committee. I'm just going to go straight to the questions, Chairperson, which are as follows. With regards to the 70 million in accruals from the previous financial year, the OCG had reported that they had to use the current year allocation to pay the 70 million invoices. So that effectively wiping out funds meant for operations and contributing directly to overspending across all programs. Chairperson, my question is, how did the OCG allow such a massive accumulation of unpaid invoices in the first place? Who authorized deferring this payment into the following financial year? And why should Parliament not view this as a deliberate manipulation of the budget cycle to conceal poor financial planning, irregular commitments, or possible infiltration within supply chain and financial management structures? Chairperson, the other question I want to ask, the annual report repeatedly thanks the Minister of Justice, Treasury, DPME, and other executive structures for their support, while openly admitting that the OCJ depends on additional MTF allocation, executive intervention, and Treasury approvals to function. Even as it overspent its own budget by 108.8%. How does the OCJ claim to be independent when its financial survival, staffing capacity, ICT systems, and court online rollout are all dependent on executive structures, thereby exposing the judiciary to subtle influence and policy capture? What concrete safeguard exists to prevent the executive from indirectly controlling judicial performance, resource allocation, and administrative priorities through budget manipulation and operational dependencies? Chairperson, once again, the annual report completely omits statistics on reserved judgments, delayed appeals, and backlogs across the superior courts. Yet the OCJ claims 100% performance in Program 2. How does the OCJ justify this fictional performance reporting when unresolved appeals, labor disputes, and year-long reserved judgment continue to undermine access to justice? Who authorized a target framework that deliberately hides the judiciary's operational failures? Chairperson, I'm very much interested in this matter of the labor appeal and labor judgments that are reserved. We are having so many people on the ground that are questioning that, because some of the judgments that are recorded, that were supposed to be recorded in the previous or in this current financial year, according to the people on the ground, they say their cases are not recorded and they have been reserved for so long. So I think the OCJ must give us a very clear answer in terms of that. How does that happen? What is the actual number, Chairperson, of labor appeals, disciplinary matters, and CCMA labor court cases involving the OCJ that remain unresolved or reserved beyond 6 months? And why has the OCJ refused to close? Why are they not disclosing this information? Is this omission a strategic attempt to conceal a collapsing labor relation environment and internal administrative instability. Unfortunately, we are very concerned because the CCMA, according to the manner in which we are assessing it now, it has collapsed. So the OCJ must assist us in getting this thing responses to this. The working class is facing problem. Cases, or their cases have been piled and not getting completed. I can quote so many cases. The case of Judge there's many cases which I can quote, which have been reserved. Others are reserved for more than 10 years, 15 years. What is the cause for that, OCJ? Why are these annual report not actually touching on those issues so that we see them getting resolved? Chairperson, the OCJ frames the May 2025 Pretoria High Court judgment on the case lines procurement as a victory. Yet the very fact that the OCJ had to self-review its own procurement shows serious irregularities. Who approved the flawed procurement process? What disciplinary steps have been taken? And how much public money has been lost through irregular ICT contracting and the subsequent litigation, Chairperson? And lastly, given the overspending on judges, fleet services, car rentals for acting judges, and the repeated shortfalls in operating leases, what internal control failed to prevent this recurring cost escalation? Have any suppliers, intermediaries, or internal officials been flagged for potential influence, infiltration, or conflict of interest relationship in the procurement of vehicles, rentals, or ICT structures, Chairperson? I end there. Thank you, Chairperson.
Madam Matava.
Thank you very much, Chair. Good morning, Chair, Minister, DM, the OCJ team members, and guests on the platform. Chair, let me start first by appreciating the presentation and thank the presenters. Chair, I apologize if this question would have been spoken to in the minister's remarks, because I had a bit of a network problem as I joined. And the question relates to finalizing the institutional independence for the OCJ to be an authority unto itself. In the presentation, we would have noted that a task team has been established, and this task team was required to have reported to Cabinet, I think, on August 2025. Now, my question, and this is where I think maybe the minister would have spoken to, because as I came in, I caught the last bit where she was talking about the independence of the OCJ, is if whether the report had been completed and submitted to Cabinet as required. And coupled to that, Chair, we've been taught that structure and finances follow strategy. So is there an anticipation that the report will cover those particular areas as well, whereby it will speak on issues of how then the budgets will be transferred, how will the personnel that perform certain functions and assets that will be required in an independent judiciary be transferred? We'll agree that there are certain shared responsibilities and functions and facilities. ICT, one of them, security is one of them, that are shared between the department and OCJ in terms of the current arrangement. Will that report cover these particular critical areas? Because we would appreciate a situation where once this particular movement has been concluded, there is no interruption on either side, whether be it on the OCJ side and on the departmental side. Chair, the second point is just a appreciation in recognizing the retention of the clean audit outcome for the past 3 years in a row, and I think 6 in the last 8 years. We commend that achievement. But having said that, I think it is important that we, or the OCJ's office, should not be complacent and say, I know what we're achieving. So the question would be, are there continuous evaluation and monitoring of areas of improvement as far as financial reporting and other related matters that speaks to the audit outcome that are being implemented to ensure that we remain ready and the office remain up to speed and steps ahead to ensure that this status is maintained going forward. Chair, whilst I'm still on the congratulatory point, I would also want to move on to the issue of commending the Office of the Chief Justice for attaining the Employee Wellness Program targets of 16 out of 16, if I'm not mistaken, and the training that is provided, which is in line with the Workplace Skills Plan. However, note with concern that the overall departmental target was not achieved. So I think it is important that on the side of the department, we be briefed in terms of what are the challenges that would have led to this target not being achieved, and what measures are being implemented to ensure that we have a skill force or a workforce that is skilled and able to respond to the modern situation as far as the skills requirements are concerned. Chair, there is an issue of overspending, and I think this matter has been touched on in the previous presentations, and I'm worried, Chair, that it is coming up again. And in the presentation, we did not hear what is the status on this one particular issue. And it's on the issue of goods and services, the car rental for judges, as they await the delivery of new vehicles for judges. Now, my question is very simple, Chair. I would have heard in past presentations in other committees that there are contracts, transversal contracts, entered into by service providers, OEMs, with National Treasury, which can provide efficiency in turnaround times. What is the status of these car rental agreements? One. Two, is there a transversal contract whereby judges can identify, or based on the determined specifications of vehicles required, the OCJ can then go to National Treasury and say, we want to procure the following. And that, for me, I think it will cut the time that it takes to procure through the normal procurement processes and bring that efficiency and save this particular over expenditure caused by car rentals that appears to be unending. Chair, whilst I'm still on overspending, we note in one of the presentation points that there is a overspending caused by an irregular contract. I'm not sure if whether did they report it as overspending or unauthorized expenditure. That is on an ICT contract. Can we just be briefed what is the status of that contract? And if whether in the next financial years, will this still be a spending? Meaning that will the contract be still sustaining, or it will have been concluded in this financial year reporting, that there won't be any further costs incurred on that particular contract? Chair, we acknowledge that the budget cuts has put a lot of pressure on functions of departments and would have led to some over expenditure. And I just want clarity. I would have heard on the financial presentation part, it was stated that the department or the OCJ would have indicated to Treasury what the budget cuts will do to their operations. Now, I'm just asking, I served in the budget committee, the standing committee on appropriations in the last administration. And there we were informed that where budget cuts are proposed, departments will be in the center of the discussions in order to identify critical skills and key expenditure line items that should be cut cautiously. At what stage did the department or the OCJ participate in these budget cuts? because I'm just concerned, Chair, it seems as if we are just a budget receiver and then make inputs post facto. Now, the question would be, did we participate? Did we give input? And if we did, how then do we still have critical aspects that will assist the OCJ to function be cut when we would have put in our inputs? Chair, the last point would be on the critical vacancies. No, second last point, I'm sorry. On critical vacancies, is just to find out, I understand that there is interaction with the DPSA in terms of how far we can go in terms of appointments and the budget that is allocated. But there should be an impact on the operations of the OCJ, as I indicated that the structure will follow the strategy. What is the impact of these particular shortages on court operations, particularly as you consider the importance of staff operations, excuse me, in registrar services and case flow? What measures are there to ensure that this particular impact is mitigated? Chair, the last one was on the issue that Honorable Musala spoke to of judgment reserves. I think I saw there was a report of about 1,500 reserve judgments, in the first 2 terms. And over 200 are older than 6 months. Now, this we can attribute to many factors. One of those could be the judicial capacity. And I would have come across where the Moseneke Committee recommendation was at 20% of increase in judicial posts. Just looking only on that one particular item of judicial capacity, are there measures being taken to ensure that the capacity of the judiciary is increased by filling posts of judges to ensure that where the impact is due to lack or the shortage of judges, that particular gap is closed? Chair, those are my inputs. I appreciate you giving me the opportunity to participate. Thank you, Chair.
Honorable Swart.
Thank you, Chair, and greetings to the Minister, the Deputy Minister, and the officials from the Office of the Chief Justice, the Acting Secretary General. I also want to apologize for being late, and if matters were covered by the Minister, please bear with me. Firstly, also commendations for a job well done with the audit and under very difficult financial circumstances. I think my colleagues have mentioned the fact that the budget cuts have had an impact, and we always need to bear this in mind when we are holding the Office of the Chief Justice and they are operating within a very constrained budget, as is the judiciary itself. And I think, Chair, may I just also distinguish between the annual report of the Office of the Chief Justice, which we're dealing with up to a certain period, and the annual report of the judiciary itself. And I understand the annual report of the judiciary is not available yet. That is a matter of concern if my information is correct. But that also brings to light the importance of us as a committee engaging with the judiciary in the new year, Chair, next year. We always do that, where we meet and discuss matters of mutual concern. And I think that is something that we just need to note, and I would formally request that we try to set up that arrangement for next year. Chair, outside of the period of reporting, I would like to ask a few questions, and again, commending our members and our staff members of the Portfolio Committee for the work they're doing on the ad hoc committee. But we're fully aware that when Lieutenant General Makwanazi made his statements and made the revelations, the Acting Secretary General of the Office of the Chief Justice formally requested the National Commissioner of Police and Lieutenant General Makwanazi to furnish evidence in support of the allegations that were made and to lodge formal complaints where warranted, either with the Judicial Service Commission and or the Magistrates Commission. My question is, has the Office of the Chief Justice received any information? Are you aware of any complaints that have been lodged either with the Judicial Service Commission and the Magistrates Commission? And then, of course, as so many people that have been watching the Matlanga Commission would be aware of the very serious allegations made by witness A relating to the impact and the allegations, which are still yet to be tested and proved, but about possible payments to the presiding judge in a bail matter relating to Mr. Molefe. That has a massive impact and a potential for damaging the whole integrity of the judiciary. We understand correctly that the Chief Justice would have discussed this matter with the presiding judge, Acting Judge President Ledwaba, and even we understand asking him to go on leave. Now, obviously, from his perspective, he strenuously denies this and that he believes he's seeking legal advice and will also appear before the commission. But does the Office of the Chief Justice have any further information relating to this, or does one then need to engage directly with the judiciary, or do we wait the outcome of the Matlanga Commission, and should this also come up in the ad hoc committee? Obviously, from our perspective, these are matters going to the heart of the integrity of the judiciary. We're also aware of allegations that touched on the magistracy and impacting on IDAC, and we are aware IDAC also appeared before the ad hoc committee. So these are all matters that are of great concern to us as members of this portfolio committee, as members of the ad hoc committee, and of course the Matlanga Commission. The challenge is, do we just wait, or is action being taken in the meantime? And maybe I'd like the Minister might want to comment on this, as well as the Acting Secretary General of the Office of the Chief Justice. Chairperson, we also raised yesterday, and I'm sure the Minister might have referred to this, the security at courts, the new security measures, and we raised yesterday's meeting the assassinations of prosecutors, etc. And yes, whilst the Minister indicates it's not a lot in 1 year, but surely every life that is lost is very important. I'm sure she would concede that. So we are concerned about the issue of the security at our courts. The Honourable Matafa raised the issue of the Moseneke Committee, and that is relating to the rationalization of areas under the jurisdiction of the divisions of the High Court. And we are all also aware from our constituency work of the complaints about waiting times for court dates. It cannot be that trial dates are only available from 5 years from now, and in other years it's 2 to 3 years. And I think, and what is so important is that the shortage of judges in the court system has resulted in very significant delays, which threaten to overwhelm the judiciary. So, Chair, again, one can point fingers at ourselves because we appropriate the budget and we have to ensure that sufficient budgets are allocated. But at the same time, we've got to act with what we can, and the Office of the Chief Justice will brief us on that, and the Minister, as to how we can address the severe backlogs, and it relates to the drastic shortage of judges and other magistrates at that level, minimum of 20%. And surely, Chair, this the Honourable Matafa served on the Appropriations Committee. I'm an additional member of the Finance Committee, so we need to accept blame for it from our perspective. We appropriate the budget. But it is critical because access to justice is a foundation of our constitutional democracy, and it can't just be a mere budget or fiscal matter. And we're going to have to put our heads together, Chair, as to find and ensure that we make use of the powers within the Monetary Bills Act to ensure the judiciary receives sufficient funding to enable them to be independent. So we can ask the questions to the Office of the Chief Justice, to the Minister, but we need to accept responsibility. As I've said many times in Parliament as well, we appropriate the final budget. So, Chair, I'd like to also just thank the Deputy Minister for his comments on going forward with the model of the independence. Yes, it's taken a very long time, and we're aware the judiciary is very frustrated about that as well. But I think he raises some very, very important aspects about accountability, financial accountability, and performance accountability. And that model, how is the judiciary going to be held accountable as a separate independent body for finances and performance? And the OCJ as a department appears before us. The judiciary itself does not appear before us because the judiciary is not accountable directly, as I understand it, to Parliament. So we need to engage with that. We also need to engage correctly what the Deputy Minister says about the future of the department. And I think this is something that we should really engage with the executive as to what role the department's going to play as one then increases the independence, the model of the judiciary is then finalized. Chair, I think there are obviously very severe concerns also about the vacancy rate within the Office of the Chief Justice. How can they do their work sufficiently? Again, it gets back to the budget, but I do want to just thank each committed staff member for their hard work in the Office of the Chief Justice, for working under very, very difficult conditions to ensure as far as possible that justice is served to the people. Thank you, Chair.
Honorable Bredenbach.
Thanks, Chair. Good morning to everybody. I apologize for the noise. My neighbour is busy doing renovations. Hopefully stop soon. Chair, I'd like to know what the reason is for postponing the annual report on the Judiciary Day. And when is it envisaged to present this report in what is really quite an important public accountability engagement? It's quite concerning that this issue is not going to be taking place on time, and we have no idea when. Then, Chair, the court online system targets have not been reached. What plan is in place to improve on this problem? The rising caseloads have reached a crisis stage, and it simply has to be addressed. Is there some way that this committee can be helpful with that? But we need to know what the plans are going forward. Then what is the plan to fill the position of the Secretary General? It's really not healthy to have an acting Secretary General for any length of time. The closing date for these applications is in March 2025. So what is the progress there? Then also I would like to know, Chair, what prompted the necessity for increased security for judges in Gauteng? Is there a problem that this committee should be aware of? Is there some way in which we can assist? And is it necessary to roll this out to the rest of the country? Then what plans are in place to implement the findings of the Musniki report, more particularly with the issue regarding the appointment of more permanent judges? It's no solution to just have a swarm of acting judges, Chair, so we need to know what the plans are there. And while we're on that issue, I'd like to know from, I think it's the Deputy Minister who makes the appointments, what are the criteria that are considered before appointing persons as acting judges? Then, Chair, there's been a staggering increase in the overdraft of the Office of the OCJ. Bank accounts, from 45 million to over 255 million in one financial year. What is the reason for this, and what are the plans to deal with this rather concerning issue? Then also irregular expenditure remains a concern, particularly with regards to the ongoing ICT contract. The irregular expenditure stands now at over 46 million. Why is this, and what are the plans to address it? And more particularly, what are the particulars of the irregular expenditure of 3.71 million that is currently under assessment? Then, Chair, we attended the inquest proceedings of the Cradock 4 in the Gqeberha High Court. And on the morning we arrived, we were expected to go through the security screening and put your bags to be looked at, etc. And the screening machinery didn't appear to be working at all. When we are, despite people being forced to go through this process. So when we asked about it, we were assured that no, it was working, that it just didn't appear to be working, but it in fact was working. When we checked, we found that none of the security paraphernalia had been plugged into any kind of electrical socket, and it wasn't switched on. It was as dead as a dodo. When we plugged it in and switched it on, it miraculously sprang to life and worked. So with regards to the abysmal security in courts, is there somebody who actually follows up on this and checks that machinery that is standing there as dead as a dodo is in fact plugged in? I'm sure that cannot be the only example of that happening, Chair. So I'd like a little more detail on that. Thank you, Chair.
Dr. Lishwit Shabalala.
Thank you, Chair. Greetings to the Minister and the departmental heads and the staff, and thank you for the presentation. You cited in the beginning as having consulted various departments, and planning, monitoring, and evaluation was cited as consultant. In my understanding, the Minister is supposed to have a performance agreement with the President that department then monitors. Did that happen? If not, yeah, it's an issue that would be taken up with that department. But from this level, I just want to know, was that consultation or was that an evaluation of this department, monitoring and evaluation as it's supposed to happen? And then the second one, it has been touched on, but I guess from a different perspective, the issue of shortages in the department. I mean, the current system of having senior attorneys, advocates, retired judges to come and work pro bono is clearly not working. I just want a comment from the department or from the Minister, because the claim is that critical trial dates are pushed as far beyond this 2029, and that trials that are lasting for more than 5 days are also just being pushed further than 2025. In that situation, then it means we are not attaining the judicial competence that we claim we are attaining. So just a comment on that. There's also an issue that keeps coming up. I would just like to hear from the department itself and not from the people who are researching our judicial system, that the matter is so bad that women judges actually face critical challenges balancing family and career demands, and that includes taking maternity leave. Not that the system does not allow, but I think the workload is such that. So maybe just an honest comment on that from the department would help. And I'm sorry to take you back to the magistrates' courts. Under your learnerships that you presented to us under education, it would have been nice to see a course developed from this department, maybe, that has to do with restoration of the dignity of the magistrate courts. I think I won't go into the issue. We all know, some of you here know it better than me, the low morale there and how those courts for years have just been berated as nothing. So in terms of policy and norms development at a Chief Justice Office, is it that not something that could be looked at, which includes, because it didn't come up even yesterday, it said that there is reported 16%, and that's reported. Obviously, the unreported, we always claim it's more. sexual harassment at that level of the courts. I'm sorry to return you back there while I have the minister. It would just be good for me to hear her comments on that and what we plan to do about it, especially approaching 16 days of activism. But thank you to the department. Thank you for the presentation, and thank you for taking your time to come and be accountable to Parliament. I think on the other issues I'm covered, especially on the monetary issues, I was covered by Honorable Mushala, so I won't waste our time. Thank you.
Honorable Mutawu.
Good morning, Chair. Good morning, everyone. Chair, I'm mostly covered on all my questions. Thank you so much.
Thank you very much, members, for those interactions.
Chairperson?
Honorable Mhlala.
No, I just have one question that I forgot to raise when I was raising my questions earlier.
Okay.
Chair, the Judicial Service Commission and the Chief Justice have a statutory mandate to investigate and address serious allegations of misconduct, particularly where there's an admission of wrongdoing and a risk to be perceived impartiality of the court. Suspension pending inquiry is a well-established measure designed to protect both the public and the judicial integrity. So, Chairperson, I'm raising this statement because in the East London High Court, there's a case of criminal injuria, a case where the judge, Judge Huddle, acknowledge even her own misconduct during her the media, when she was taking an interview with the media, that she admitted emotional breakdown and the acknowledgement of misconduct in a written. I mean, she admitted emotional breakdown, and she even went as far as saying that she went to the staff member to offer a peace offering. So she called the staff member K-words. The staff member have reported the matter to the JSC, have reported the matter everywhere he can do. A criminal case have been opened in the East London SAPS. But my question is, why is the OCJ not acting on this matter? The judge calls other staff members K-words, working with them, the staff members K-words, and is that allowed? The judge is still working, the judge is still there. And what about the integrity of the our courts if we're going to allow simple things as like that to happen? I think, to be fair, Chairperson, the judge should have been suspended. Can the OCJ tell us how far are they with that matter? Thank you so much.
Honorable Swart, is that an old hand? Honorable Bredenbach, is that an old hand? Okay. I guess those are the legacy hands. Minister, can you start giving responses?
Thanks, Chair. Can I request that the team start and then I'm able to wrap up? In the boardroom, there are quite a number of issues that relates to the finances, but I'll cover, acting as some of the areas that I've been working with. I can, what I would be able to, together with the team. Please start in the boardroom and then I'll close, Chair.
Okay, let's do this. Let's give the team, then give the DM, then you do the parting shots.
Yes, thank you, Chair.
Sure. Acting SG?
Thank you, Chair and members, for the questions. I'm going to take it from the top, and as the Minister indicated, the team is ready to assist me in that regard. I would like the members, I'm slightly concerned today. We have a Judiciary Day on Tuesday, where the Chief Justice will release 2 annual judicial reports for the 23-24 financial year, as well as for the 24-25 financial year. And both will be released at the virtual Judiciary Day on Tuesday. Invitations were sent to the members. And as the members would know that the judiciary used that Judiciary Day to account to the public, and questions relating to judicial performance should kindly be raised there with the panel that will be ready to respond to questions of invited esteemed guests, as well as a media briefing there afterwards. Chairperson and members, just to highlight that the OCJ is the administrative arm of the judiciary, and we do not report on judicial performance. Judicial performance was delineated from the OCJ's performance in 2018, and since then the judiciary has been reported on their performance through the reports. That includes the reserve judgment reports, the judicial annual report, and these questions relating to judicial performance should kindly be referred to the judiciary then on this Judiciary Day, scheduled for Tuesday, 25 November, starting promptly at 10. And then let me go back to my questions. I want to touch on security quickly. Members and Honourable Chair, we realize that our security measures are not sufficient for the judiciary, and we would like to improve on that. Hence, we will start to improve our security entrance and equipment next year, and all courts equipment will be replaced to enhance the security. And where we can't do it with the available funding, we will then, as the Minister has indicated, join hands with a private, public-private partnership, such as Joburg High Court, where we are busy looking at the enhancement, as Honourable Member Breitenbach has noted, on the increased security measures proposed in both high courts of the Gauteng division. I'll leave the budget issues for the CFO to address, just to mention the impact of court operations and the critical vacancies. That is, there's a dire need for us to review our registrar offices, as the resources in our registrar offices doesn't reflect the increase in the workload. However, with the rollout of Court Online, we are beginning to see a quicker turnaround in our caseload, but the volumes require more resources. So that workload analysis and study is part of our organizational structure review to ensure that the needs of the judiciary is properly or are properly addressed through the creation of immediate and critical needs. Court Online, yes, until there's a proper new contract in place, unfortunately, the expense will be irregular and noted in our reporting. We are confident that the CITA will assist us sooner then later to indicate to conclude a new contract in that regard. We are working closely with Department of Justice on the task team, and as Treasury has also confirmed, funding will follow function. And we have started with commence with meetings so that we can get clarity and ensure a smooth transition when we transfer these services after concurrence from the judiciary was given. Honourable Swart mentioned about the letter that was issued from my office. That is correct. To my knowledge, there was no formal complaint lodged yet, but that matter is also within the JSC space, which is directly linked to judicial performance. The same with Honourable Mushlala's question. The JSC and Judge Hartel, that matter has been reported to the JSC, and further information can be provided through the JSC and JCC. Unfortunately, the OCJ is not mandated to report on the performance of the JSC, and there is a spokesperson appointed for that purpose. I may mention with regard to the sexual harassment issues that the Office of the Chief Justice has assisted the Chief Justice with an interim gender desk to address all gender mainstreaming and the sexual harassment policy that was released. The office will then also, or has started to look at the establishment of a permanent gender desk to support the Chief Justice in that regard. Chairperson, with your permission, I hand over then to the CFO for the financial related as well as judges' vehicles. Thank you, CFO.
Thanks, Chief. Thank you, Chair. On the issue of the 70 million raised by Honourable Muthala, the 70 million is not because we didn't plan, Chair. We on the beginning of the financial year, we do have demand plans, and then all these financial years we've been indicating that there's this thing when the National Treasury cut the budget. We indicated to National Treasury we've got contractual obligations. For example, the budget for 24-25, they cut 138.5 million. On that 138.5 million, we had already committed some of the procurement. For example, we on the contractual obligations, we've got judges' vehicles. According to Section Act 47/2001 of the Judges' Remuneration Condition Employment, judges are supposed to be given a state vehicle. So on that part is the contractual obligation that we need to have it on a yearly, and we cannot even say to the judges, we'll cut here and here we cannot allow you to drive these vehicles. So we are obligated to provide those vehicles. So these vehicles have been leased through G-Fleet. I'm also addressing the issue of Honourable Matoba to say we then go to National Treasury. What is happening here? We contracted with G-Fleet and GMT, which is the one in Western Cape. So these vehicles, they've been leased to OCJ for 4 years. So 4 years, and then when the judge can then replace, if it's 4 years or 160K. So the delays is then when G-Fleet and GMT are supposed to deliver those vehicles, it takes long. So when we then have those waiting for those vehicles, then the operating lease kicks in. That's when now most of the budget is then we overspend under goods and services. But in that area, National Treasury has, on the additional budget they've given us, they've given us 45 million for this financial year, and then the next financial year is 43 million. We have started a procurement where OCJ now procures these vehicles. We are now going to reduce renting these vehicles from G Fleet and GMT because their monthly fees, they're expensive. So OCJ has started procurement. We've procured almost out of the 45 million, we've already committed 25 million for the vehicles, where now OCJ will own these vehicles, will no longer be paying the monthly rentals to this G Fleet and GMT. And in this process, we are using National Treasury Transversal Contract, which is the RT57, and we are also doing the 3 quotations because according to the Act, the vehicles that judges are supposed to procure, I mean, they are supposed to be provided with. In most cases, they are not under the RT57. So we go through the 3 quotations. So even the 3 quotations is much quicker than the G Fleet and GMT vehicles. So that's the reason why we then had the 70 million or as accruals because of those judges' vehicles that they are contracted. We've already committed the 138 million that was cut from our budget, then resulted for us to have these invoices. So we couldn't pay those invoices in the year 23-24. Hence, we then had to hold those invoices and pay them in the next financial year. And we've put controls in place with the current budget to ensure that we won't overspend. As I've already said, one of the controls is we are now doing outright purchase where we are procuring these vehicles for judges as OCJ. We are also procuring the vehicles on the relief vehicles for acting judges. The courts own these vehicles, and then when the acting judge comes, we then provide them with those vehicles. That will make us to also save under goods and services on the current house. On the overspending of goods and services, as I've already indicated, is those issues of budget cuts, because we've already committed most of them, and then also travel and on travel and subsistence. Most of the traveling for judges, especially at circuit courts, the other overspending also, it was when we do training for judges and in magistrates, under our travel and subsistence also, we had budget cuts. As I've indicated when I presented, budget for SAJ only under goods and services was 2 million. But due to training, we ended up spending 7 million. The same with JSC. We budgeted 2 million under goods and services, but we ended up spending 6 million because of the sittings of the JSC. So on the irregular expenditure, Chair, is the issue of the contract that we then, like the SGS already indicated, also the issue of CETA. Previously, we didn't go through CETA, then it resulted on us then contravening the regulation, then hence all this contract that we then contracted with them without CETA. We are including them under irregular until those contracts have been finalized. So we will continue to include them until we finalize those contracts. The budget cuts, normally OCJ was not consulted when the budget cuts were done. Hence, we ended up with 138 of budget cuts because we were not consulted as OCJ. The issue of overdraft, Chair, is as a result of this budget cut again. So we'll continue to have this overdraft until National Treasury. We've submitted the issue of unauthorized expenditure, this overspending. Then through presentation at Parliament, that we believe that they will give us this money, then we will clear this overdraft. Thank you, Chair.
Thank you. Acting SG, is your team done?
Chairperson, from my notes, I think we've addressed all. Just one correction that I want to make. Honourable Breitenbach mentioned that we did not achieve the court online target. That we've exceeded the target actually. So we are on par, only 2 courts left, and a date is to be cleared. Thank you, Chair.
Thank you, dear.
Chairperson and honourable members, thank you very, very much. Look, I think just I want to thank the Honourable Swart for his, I think, very, very insightful and useful remarks regarding the issue of the judiciary-led court administration model and the importance of developing appropriate forms of accountability in respect of both finances and performance. I think he points out correctly that at present the Office of the Chief Justice interfaces with Parliament, but that the judiciary, as the judiciary, do not. And I think our collective wisdom needs to guide us as to what would be the appropriate form of accountability and engagement, which both emphasizes the need for that accountability, but at the same time, that it's done in ways that are appropriate to the dignity and the role, the constitutional role played by the judiciary. I think the issues relating to a number of questions have been asked about Judiciary Day and the tabling of the annual report. I think the acting SG has dealt with that adequately. But I think the question that would arise for members of Parliament is that once that report is tabled and put into the public domain, how does Parliament, as the elected representatives of the people, interface and engage with the judiciary around that report? The second issue I just want to both clarify and expand upon a little bit is the question of the appointment of acting judges. No, I do not. It is the minister who appoints acting judges. The minister has delegated to me responsibility for the appointment of acting magistrates and for the appointment of small claims court commissioners. Maybe just to say that as we indicated during previous engagements with the portfolio committee, we are at a very advanced stage of revising the policy and the guidelines for the appointment of acting magistrates to bring it more closely, to put it on a firm constitutional and legal footing, to bring it more closely, to be closely aligned to the draft policy for the appointment of acting judges. At present, I can just say that we do go through a very rigorous process of screening those who have been put forward for appointment as acting magistrates. That includes the relevant regional court president or chief magistrate, conducting an interview with persons. We have quite a lengthy checklist which covers areas around professional standing, any criminal record or current charges, whether they have civil judgments against them, credit bureau issues, any potential conflicts of interest, and also we require certificates of good standing from the Law Society, the Legal Practice Council, rather, and so on. So it's not something that's done without thought. Having said that, we do hope that through the introduction of these revised policy, there will be a lot more transparency in the process, and we are trying to move towards a situation where the process is opened up, where those who have an interest can apply, get screened, be put on a pool, and also increasingly try to link that to the work of the South African Judicial Education Council, so that institute rather, so that those who aspire to act can also receive the necessary training and preparation. On that note, Chairperson, I conclude with my very, very last point, and that is that The South African Judicial Education Institute Amendment Bill has been approved by Cabinet. It has been introduced in Parliament, and it would really be to use this platform to appeal to the committee to also give speedy attention to the processing of that bill, which will in its own way contribute to building the institutional independence of the judiciary by providing for a judge or retired judge to be the dean of the Judicial Education Institute. With that, thank you very much.
Thank you, Minister.
Thank you very much, Chair, and thank you, members, for the questions. I think the team had responded to quite a number. Maybe just to be clear to Honorable Mohlala, perhaps because I think the other colleagues, CCMA falls under Department of Labor, not under us, nor even the judiciary. So it's at Labor portfolio. But two, as indicated, the annual report of the judiciary will cover all those issues that are relating to reserve judgments. It doesn't fall under this OCJ. OCJ is the department that is still under the executive authority of the Minister of Justice. So the Minister of Justice still accounts on this. That's why it's me here. And that's why you'd find it's not an issue of minister or Minister of Finance wanting to influence the judiciary informally or in a corners. This is what the legislative environment is currently that we are using until we have a bill that removes the minister as executive authority. Therefore, then the judiciary will be independent. That's why when I spoke at the beginning, I spoke about the issue of the accounting and executive authority of the judiciary going forward. Currently, the executive authority is the Minister of Justice. So there isn't any influence. And that's why how we ensure the separation of powers is to ensure that the minister is responsible together with the OCJ for administrative and finances, and the judiciary is responsible for what happens in the courts, judicial matters. And that's why the annual reports will be different. It will be annual report of this one, and then the Chief Justice on Tuesday will table the annual report for the judiciary. Yes, it has been delayed. I think several members spoke to this. For various reasons, there's been quite a lot of activities even within the judiciary, J20 and others, but it is going to be presented next week, and the Chief Justice will deal with that. So all those issues about Labour Court, Labour Appeal Court, and all those are falling within that area. Number two, it's the issue of the annual reports. We present an annual performance plan to Parliament, and Parliament approves it, and we account. The annual report mirrors what we have presented to Parliament as annual performance plan. So we are counting against the annual report. So there can't be a deviation between annual performance plan and the annual performance report as we do the reporting. Honorable Matafa spoke. Yes, I did, Honorable Matafa, at the beginning. I spoke about the process. We have been to Cabinet, and I reported that the process is in two phases. The first phase, it's where we transfer shared services from the Department of Justice to the OCJ. The plan was for the 1st of April 2026. We're still working on that, but it's not yet confirmed because the judiciary has asked for some time to look at various issues that they are concerned about. Once we know, we'll be able to. The second phase will be the phase 2 that we talk about, transferring of the lower courts to the judiciary, to the OCJ. And also the removal of the Minister of Justice as the executive authority and all those things. But the constitutional obligation of the minister remains in terms of overseeing and ensuring that there's access to justice, so as per the Constitution. So things that do not need constitutional amendment and are legislative will be transferred, such as magistrate court will be transferred to the OCJ as part of the issues. And that is the second phase that we intend to. How are we ensuring operational continuity is that the teams, as I said, they are streams. So there will be a stream that focuses on security, there will be a stream that focuses on ICT, and they look at the mirror and look at where we are. If the contract has ended, they work together in terms of the new approach towards a contract. Where there's still contract, currently we're working together in phase. So that is at the operational level that is being dealt with in terms of that. On the transversal contracts, unfortunately, OCJ can't participate because the transversal contract of Treasury is below the amounts that we're spending on the cars. You'd note that the cars for ministers were reduced, but the judiciary's cars remain at that level that they are. I think it's about above 1.5, which the ministers are not. So the currently transversal contract doesn't sit at that level from what we had gotten in terms of that. But I think there are things that the judiciary will have to look at, and as the acting SG and the CFO have explained in terms of how we try to manage the issues in that. Yes, previously, and this is why myself, Minister of Finance, and CJ had several meetings, the issue of budget cuts. So we went back to sit with the Minister of Finance, and I'm grateful because he's been quite open about the engagements and what finding solutions within the constraint of the broader fiscal environment. So one of the issues we raised first is that because the budget of the judiciary is entangled in the budget of the department, so when the department's budget is cut, it's not visible where they shouldn't cut in terms of the judiciary. Because in terms of law, like in parliament, they shouldn't cut. Where there are budget constraints, it must affect in terms of the executive, but not the legislature and the judiciary. So they have not been able to cut the legislature, but they've cut the judiciary because that budget sat with us. And that's the conversation we've had. We've been able to put mechanisms in place together with the Minister of Finance to be able to change that. You would have noted during the MTTB, he was able to put an adjustment. I was trying to check my figures because ASG and my figures are different in terms of support, because we had agreed with the Minister of Finance to put aside about 200 million to close the gap in terms of the work that has been there. I'll have to go and check in the final appropriation, Chair, if that amount is exactly how we have agreed. And it's part of the conversation. But similarly, one of the areas we've agreed, which I will be going to Cabinet on the second, actually next week as well, to request approval of the appropriation or allocation of funds in terms of CARA, and OCJ is one of the areas that we are looking at closing the gap in terms of the infrastructure gap that is there to capacitate and support. So that's where we are. We have taken a conscious decision as the executive to support the judiciary fully. We've been having quite extensive discussion between ourselves, the judiciary and finance team, led by the minister, to ensure that going forward, there are no gaps, there are no weaknesses in terms of cuts, but we are able to give that full support as the executive to the judiciary within the available resources. So that is important for us to be able to deal with that, Chair. So that I think I've been able to respond. On the issue, I think it's been raised by quite a number of colleagues. On the issue of filling of vacancies of the judiciary, it's several issues. You'd have noted that JC said for 2 weeks in October to fill vacancies. It's not only because of the finances, but also the caliber of people that comes through. So, for example, when you see that there will be interviews, and because they are public, and I think members will see, you find that in Mpumalanga we had 2 vacancies. Only 1 candidate could be appointed, not 2. You'd have we had a vacancy in Eastern Cape that couldn't fill. So you do have those things. That's why continuously we encourage members of the sector to avail themselves to act, to gain experience, but also it's also because the JSC is rigorous in terms of its interviews, but also in ensuring that there's high ethical level of members. And because over time now, we're seeing members of the judiciary being impeached. So people do know that there are consequences that are being implemented in terms of the work through JSC. So the issue of filling of vacancies vacancies are various. The judiciary would have to identify per courts, and also we are linking that with the rationalization. But currently, the issue is just the issue of vacancies that are there. You would note now that the adverts have been opened for April interviews. So that as well, depending in the caliber and the people that comes through, if we'll be able to fill. But we've been able to fill quite a number of them in terms of the judiciary. The judges, we have made recommendations now to the president, which we're hoping that should be approved in any time and then be announced publicly. All those, but Jesse has announced those vacancies that will be filled. Again, in the magistrate, I think somebody, Honorable Litchfield Chabalala, mentioned around the magistrates. We have also filled the positions, about 65, if I'm not mistaken, of magistrates in terms of that. That will be announced. I think that's starting from the 1st of February, 2nd of February, because it's linked to their training with SIJ. So that is important as well. So the filling of vacancies to ensure that court roll means court delays are not only because of vacancies. Yes, the reserve judgment as well. That's why even at JSC, when people come for interviews, we ask them, how long have you been? We have a case now in JSC. You would have seen a statement issued yesterday. What is today? Friday, on Wednesday, of a judge that is taken through tribunal because did not issue judgments in time, more than a year. It's going through a tribunal process. Though the person says, I've changed, I've done, but it's going through. So there is consequence management for judicial members or presiding officers who do not issue judgments in time, and they get to are dealt with by the tribunal within Judicial Service Commission. So there are examples we can give members in terms of that. But Parliament has a representative chair. I think one of the issues that I find as a gap is that you have these representatives that are representing Parliament at these bodies. The issue is how do they account and where do they account? And perhaps this is what Parliament needs to look at, especially ourselves as the Portfolio Committee of Justice. You have an interest. You have members of Parliament who sit in the JSC. You have members of Parliament who sit in the Magistrate Commission representing Parliament for both houses, by the way. And the issue is that in terms of their mandate, what they do there and how they report back. Do we find a mechanism? We do need to find a mechanism of interaction, because you've got to, as Parliament, to hold them accountable. If there are certain things that are not happening, yes, the small JC, they don't become part of it, but on the interviews, on the filling of vacancies, Parliament is represented. And they would have quite a lot to give feedback on, and even how the operation happens. Perhaps it's one of the issues that we can look at. It's the minister who sits in terms of disciplinary or tribunals, in terms of the small JC. That's where we sit, but the others are sitting on. So we've got to try and look at that. So hence I said issues of functioning of courts and issues of dates, it's a system issue from legal representatives, from who would pay the accused, especially on criminal court matters. They will delay forever. And some of the interventions, for example, that the judge presidents will do, will write to us and request us to assign, for example, a retired judge, if it's a trial that is going to sit consistently for a long time. Let's say it needs about 4 weeks and you can't utilize a current serving judge because that retired one can come in and do like we're doing. If you look at the Senzo Meiwa trial, it's a retired judge that has been asked to come back and sit through that judge. He's got nothing else except that trial so that it can be able to finish. So there are those interventions and availability for the judge presidents to be able to implement. And we do sign and authorize for those retired judges to come and do that work in terms of support, especially to ensure that those that are taking time from other court roles so that it doesn't deal with that. And then as part of the work that we give feedback as well. So would like to know where there are issues as well. Specifically, you'd know that the court online system as well was introduced particularly to try and manage in terms of issues of court roles, issues of efficiencies, and also transparency, so that we don't have these complaints about dates being manipulated or things not moving. At least it's now going, and it has been moving faster than initially proposed, which is important and it helps. And I was saying to the team, one of the issues that we've got to look at is to say, how does this court online then go into our magistrates level? How do we take it? Because it will help in terms of management of the capacity there. Honorable Swartz, as DM said, definitely we are in support of that, of the work that is being done by the judiciary ourselves, but also we do believe that it's important. And I said to the colleagues when we met with CJ and the heads of courts, I said, the president has been very clear to me as the minister to say he wants this done and he wants it as in yesterday. So that's why we've been working full steam. That's why we quarterly, this is a standing item, but not only quarterly, but also we do find mechanisms to say in between, if there's something that we need to do, we need to really be able to interact. I think even at some point, even the judiciary were shocked to see how fast now we are starting to move in terms of saying this can be done, this can be done, this can be done. The next phase, what we want to do, beginning of the year, once we get feedback from the magistrates, we'll be engaging with labor. Because there are stuff that we are starting to do, because the work, the stream of human capital is starting to identify those that are in the department that would actually have to be transferred to the judiciary in terms of supporting the work, and also the conditions of employment of those that are in the OCJ. Because the minute the legislation comes, their condition of employment is going to change, because they will not be under public service and administration. So we'll be bringing in the Minister of Public Service and Administration at the beginning of the year to start engaging with labor at the bargaining council to say this is the process and get their inputs. And also it's going to be a process that employees will indicate their availability. So it's a massive project that we are working on, so that the employees can start indicating, I want to remain in public service. Is it possible for them to remain in public service? And what would be, where are the positions? How do we close those? So it's part of what we will be doing. I think one of the members asked about that in terms of human capital and what we are doing. So that's the work that we are doing. We are committed as the executive, and also we are going to come fully, Chair, to you as we start looking at the policy proposals, because we don't want to come to the legislation that you are going to reject as Parliament. We would like to have a buy-in from you as parties in Parliament prior to it being, because it will not serve purpose if we come right at the end and we have excluded you. So as DM has said, I won't go into detail. The issue of, as I spoke about the issue of the judges and the backlog on the Mseneke report, the security, we are dealing with it as when we assess. It's based on case by case. I mean, as the issues in courts complicates, yes, it does, and it's something that we shouldn't, but we are dealing with it, where assessments are being done, judges are being protected. We're trying to make sure what are the models of courts that should be, where the entrances are not the same as the public for the judicial officers and all those things. So we are looking into that, and that's why the precinct in Johannesburg, we had to change and include, because there was issues not only by presiding officers, but even those who are coming to court. So engaging with Gauteng, for example, to be able to provide even shuttles amongst our courts so that it's safer, and creating a court precinct in that area. So there's long-term issues that we're looking at to be able to support the courts from government point of view, but bringing all the partners to help us. The issue of what is happening at the Commission and the Portfolio Committee, we are not waiting for the end, Chairperson. We are also dealing with some of the issues that are immediate. As I said, in the prosecutorial environment, the issue is that the ethics office works and deals with the issues of that. If we look at, Honourable Member, and I don't want to go into detail because we've agreed as government that we're not going to run commentary throughout. But if you look at Witness A's statement, he said, which are because it was either a prosecutor or a judge, which is in our portfolio. So we're waiting for that final information around that so that we can deal with it. Yes, as you observed, Judge Letoba as well issued to say he would like to have his day to respond and would like to provide that. the view as well, we need to separate as well what can go to Jesse and what will go to the courts themselves. Because if it's a criminal matter, police must arrest, irrespective of who. That's what the Constitution says, and that's what the law says. So it's not a matter that we must go see. It's not if it's a crime that has been committed, it's not an impeachment matter. It's a criminal matter that must be processed in terms of Criminal Procedure Act. So that also needs to be clear in the public, that where there's issues of criminality, it doesn't mean that the country will say, because he's a judge can't be arrested, will go through GSC, because I think Honorable Mushala was sort of saying that, no, it's not true. The Criminal Procedure Act and the laws of the country says no one is above the law. And therefore, if I have committed a crime, irrespective of my position, irrespective of my standing in society, I get arrested, and that's it. So that's where we stand, Honourable Member, in that regard. We are working with for example, the CJ will work with the judiciary from judicial officers. From our side, we are working with those that sort of are flagged, so that we can take appropriate action. So far, we've not had directly naming of a person that has done wrong in this area. There's insinuation, and the issue of IDEC is currently in court. We'll wait for it to look at it, how it pans out, and therefore through relevant legislation, for example, that allows the minister will be. But I have written to the NDPP to say the issues that are coming up out of this commission, and actually in terms of the ad hoc committee, are worrying. Leave the issue of implicated individuals, but the gaps in terms of overlapping of responsibilities, and that's what we are starting to deal with, so that we don't wait, because we can see where the clearing issues are, the issues of mandates, the issues of oversight. I think even NDPP made a mistake to say, I have appointed a judge. I've not appointed a judge. We've made a recommendation for the president. So we've worked together to make a recommendation. We're waiting for that to be confirmed by the president, so that there's oversight over IDEC. So that work is being done. It took some time as well in terms of that work that needed to be done. On the issue, Honorable Breitenberg, I did speak about the issue of SG earlier on when I started, and also the issue of Judiciary Day postponed. It has been reported. The implementation of the Museneke report will be done once we come back from Cabinet. We went back to the, as I said, on the 13th of November. I met with the Judiciary and we presented. We are going to Cabinet with it, and then we'll start implementing. We can't implement before the Cabinet does approve. Security of courts has been done. Acting judges, I currently work together. There's a framework. Thank you, Honorable President. Currently, there's a framework that is being used for appointing of judges, acting judges in the high courts, in superior courts. So the judge president makes proposals in terms of those that are acting, and then the minister approves those. There's been a request from legal sector for transparency in this regard. We have agreed, I've brought it to the attention of the heads of courts to say we need to find mechanisms of ensuring that the legal fraternity doesn't continue to raise this, and it's one that we are working on. We've said that we need to start working on the review. I've requested that they start working on that and make proposals, so that next time when we do, we approve. We've tried our level best as part of the work to improve. Honourable member speaks about pro bono. Pro bono, Honourable Litchfield Shabalala, is part of the legal requirement. So those who are practicing have to continue to do community work, and part of the areas that they contribute is to do pro bono. It's not because they are forced to say come and do pro bono, but some who wants to gain experience in the bench, which we encourage, do that pro bono in support of the work to gain experience. It's something that is a good practice that we must continuously encourage. It's not something that is not ideal. I think it's good to have community service to give back as a professional to the sector. I think we must continue to encourage. The issue of consultation by the team with MNE, it's required by Department of Monitoring and Evaluation that every quarter we submit to them the quarterly performance. Annually, they look at our plans, we submit to them, and also the annual reports we submit to them. That's the context they're making. My performance agreement, yes, is with the president in terms of the work that we do, and the annual performance plan of the minister or agreement of the minister doesn't have everything. So there are specific strategic priorities that you are expected to meet as the minister. So it's not operational matters, it's not everything under the sun. They become specific areas that you agree with. And then those are needing to be less than 10. And then you agree on those, then you report on those as part of your performance as a minister. I hope I've answered all the issues in terms of that. Honorable Mhlala, the JSE investigation of the judge calling members K-Wade and all that, I'm not aware of it, actually. If you can send that, this is what I will encourage as well, Honorable Mhlala. When we come across such matters, do a formal report and a formal complaint, substantiate or ask those people to give you documents. You have a right as well as a member to write directly to JSC Secretariat and say, I have a complaint, I've come across this one. If there are case numbers, like you say, you give us the case number, I can assure you it will definitely be processed. We even get special sittings if there's a matter that we needed to look at and we are not scheduled. And then the small JSC meets and look at the matter and formally refer them to tribunal. But what happens is that once we receive it, the Secretariat receives it, they do evaluation of it, they will ask for document, verify the information, and determine, okay, there's valid case for us to proceed with it, and then they forward to JSC, and then out of that, then the small JSC will look at it and then refer it for tribunal for the person to come, for the judge to come and answer. And when the JSC meet, the small JSC meets, depending on the nature of the matter, that's when the JSC will take a decision whether to suspend or not. It doesn't happen that the JSC or the Chief Justice or the Minister can decide that you are suspending. Including with magistrates, it's the same approach. You write to the Magistrate Commission to complain. The Magistrate Commission will do evaluation work. Then the Magistrate Commission will sit, evaluate, and then write to the Minister to suspend the magistrate, and the minister will confirm and submit that report. With magistrate, that report comes to you with a suspension and also with a firing. With the Judicial Service Commission, the report comes to you in Parliament for impeachment at the end of the process. Chairperson, I think I have answered the questions. I don't know if I left out anything. I'll be willing to do. I think I've been even talking too much for a long time. Not too much, I've been talking for a long time. So I'm even worried about your time, that I seem to have taken over your committee. Sometimes it's the passion. We've been doing a lot of work to try and turn around the situation, Chair, and appreciate this platform to be able to explain ourselves very well. Thank you, Chair.
Yeah, also the reason why we allowed you to proceed is because you are actually assisting issues that were raised by members, which I think it actually assists even some of the concerns that were allayed by members in respect of the issues happening in the country, in the judiciary, in the OCJ. I think just few issues, members. I won't be doing any closing remarks. I think we've covered a lot of ground in respect of this annual report from the Office of the OCJ. Of course, with their challenges that they've reported to the committee meeting. I think all we can conclude is that currently you are still doing well, and we wish and hope that the Secretary General to be appointed will be able to keep the momentum or even improve more in terms of the work that has been done. Consistently, the OCJ always acquires a clean audit, and it's commendable that you are clean in terms of accountability on the work you are doing in the department. Also, what raises something that we have always been talking about. There are issues that relate to the committee and the judiciary having to work together in relation to matters of mutual interest. And we've always annually had meetings with the judiciary in respect of mutual issues of mutual interest. And I think now we're just overlapped by a number of issues relating to the parliamentary program. Otherwise, initially we had thought that we'll be able to cover up that meeting this year, but it looks impossible given the parliamentary program. So I think it's part of the issues that we must prioritize first thing in 2026. Members, the Chief Justice did send us an invitation to the annual Judiciary Day that will be on the 25th virtually. 25th is Tuesday next week. So we'll encourage members to actually attend and partake in the Judiciary Day. Myself, Honorable Bredenbach, and Honorable Nomvalo, and Honorable Glober are possible going to be in Hosimamburu Correctional Center the whole day of Tuesday. But the committee secretary will facilitate the link relevant to the annual Judiciary Day so that members can actually attend. With that, members, I don't think we must drag the meeting any further. Minister, thank you very much for always coming to give clarity and fill in the cap that we always, the oversight cap of the portfolio committee. It always helps, and if we are to work in this manner, I'm telling you, we'll be able to overcome a lot of challenges, because we'll be working as a collective in terms of tackling all the issues that we are actually faced with. Members do go to communities, come with issues that are reported by community members. Every day I get messages. So what I do, I just forward. If no, the minister, this and that, I forward to the minister. The minister responds, I forward to the complainant. So that we're able to speedily attend to issues raised by community members. DM, thank you very much for that fulfilling engagement also in the portfolio committee. We have had a way of what then is the next step in attending to our issues collectively. So as leadership of the country, our people are looking at us. We don't have the luxury of saying when we get some community issues, no, it's not me, it's that one. No, we don't do that. You take that matter to where it is supposed to be addressed. When it's addressed, you take it back to those who are complaining. Acting SG and the entire team of the Office of the Chief Justice, thank you very much. Keep up the good work.
Maybe before you leave, maybe Marlies can explain how the Judicial Day operates so that members are ready. I think they can pose questions, isn't it, Marlies? Yes. So you're allowed to pose questions during the sessions.
Yeah. Actually, we are allowed to engage the annual Judiciary Day. Who is talking?
That is me, Chairperson. The program will start promptly at 10 o'clock from 9:30. All invited guests will be allowed access to the webinar platform. This is a virtual release. All invited guests will then attend the release. The keynote address will start shortly after 10, after which all invited guests may pose questions to the panel, Chief Justice and the judiciary on the reports that were released. We will allow, I think it's 45 minutes, questioning and answering, after which a break will be introduced and the media Q&A will start. So thank you, Chair. That is the operational proceedings for Tuesday. Thank you.
Okay, that's fine. Thank you. Thank you very much, Acting SG. Members will formulate a report in respect of this annual report. Then we'll have to come back and adopt those reports for the attention of the House. Thank you very much, colleagues. The meeting stands adjourned.
Thank you, Chair.
Thank you, Chair.
Thank you very much.